What is an indictment or information at arraignment? Imagine standing in a courtroom for the first time after being accused of a crime. The judge is about to tell you what you are charged with. That moment is called the arraignment. But what actually happens during that time? Well, it all starts with a formal document that spells out the charges against you. These documents are called indictments and informations. Understanding what they are and how they work can help you see what's happening in this important early stage of the criminal justice process. An indictment is a formal accusation issued by a grand jury after they review evidence presented by a prosecutor. Think of a grand jury as a group of citizens who decide if there is enough evidence to charge someone with a serious crime. They look at the evidence and determine if there is probable cause to believe the person committed the crime. If they agree, they issue an indictment. This document lists the specific charges and the facts supporting them. Indictments are usually used for serious crimes called felonies, especially in federal cases and some states. They act as a safeguard to prevent people from being accused without enough evidence. On the other hand, an information is a formal charging document filed directly by the prosecutor without involving a grand jury. Instead of a group of citizens reviewing the evidence, a judge or magistrate looks at the information. They check if there is enough probable cause to move forward. Informations are often used for less serious crimes called misdemeanors and some lesser felonies. They are common in jurisdictions where a grand jury is not required for certain charges. During the arraignment, which usually happens soon after the arrest or after the indictment or information is filed, the defendant appears in court. The judge reads or summarizes the charges listed in the indictment or information. The defendant is told what they are accused of and is informed of their rights, like the right to have a lawyer and the right to remain silent. Then, the defendant is asked to enter a plea. They can say guilty, not guilty, or sometimes, no contest. This plea is their first formal response to the charges. For a criminal defense lawyer, the arraignment is a key moment. They review the indictment or information carefully to make sure it properly states the charges. They check if the charges are clear, legally valid, and filed in the correct court. If something is wrong, they can challenge the indictment or information early on. This step also sets the stage for pretrial activities like motions, discovery, and negotiations to resolve the case. In short, the indictment or information is the official document that charges someone with a crime. The arraignment is the court proceeding where these charges are formally presented, and the defendant responds by entering a plea. Knowing what these terms mean helps everyone involved understand what's happening and prepares them for the next steps in the criminal justice process.